Mr. President, distinguished members of the Court, it is an honour to appear before you today to continue the Gambia's presentation. You have heard over the last 3 days the evidence and legal submissions underpinning the Gambia's case that Myanmar committed genocide against the Rohingya. I will address you this morning on the other breaches of the Genocide Convention, which Myanmar committed in the course of its genocidal campaign. My focus will be on its violations of the duties to prevent and punish genocide, and on its responsibility for other punishable acts in Article 3. Mr. President, the suite of obligations contained in the Genocide Convention are together intended to ensure the effective protection of groups against genocide. Each of the codified duties is important in ensuring that the framework created by the Convention is robust. Each of the duties constitutes recognition by the contracting parties that for the Genocide Convention to be effective, it needs also to target acts ancillary to genocide. And it needs also to require that states create effective domestic frameworks and take protective steps against genocide. Thus, by Article 1 of the Convention, states parties undertake to prevent and punish genocide, obligations which the Court confirmed in the Bosnia judgment also place states under an implied duty not to commit genocide themselves. Article 3 then sets out punishable acts under the Convention. These include, in subparagraph A, genocide, and also in subparagraphs B to E, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. Next, Article 4 contains a duty to punish the perpetrators of genocide irrespective of their status as constitutionally responsible rulers, public officials, or private individuals, a provision which supplements the overarching duty to punish in Article 1. And by Article 5, contracting parties undertake to enact the necessary legislation to give effect to the provisions of the Convention and to provide effective penalties for its breach. Article 6 then completes the set of obligations relied on by the Gambia by imposing a duty to try perpetrators of genocide, either in the domestic courts or through a relevant international tribunal. Each of these additional obligations is central to the Convention, to its achievement of its purpose and its function as a whole, and they are also central to this application before you. Their importance has been underscored by many of the interveners, in particular by the 6 joint interveners, by the Republic of Ireland, and by the Maldives. The evidence in this case shows that alongside its commission of genocide, Myanmar committed material breaches of these other provisions of the Convention too. In particular, the evidence shows that Myanmar is internationally responsible for violations of the duties to prevent and punish genocide, and that it conspired to commit genocide, and that it directly and publicly incited genocide. I will address each of these breaches in turn, beginning with the duties to prevent and punish genocide as contained in particular in Article 1. Mr. President, the Court's Bosnia judgment makes clear that Article 1 creates its own substantive obligations, distinct from those which follow in the remainder of the Convention. And its 2 facets, to prevent and to punish, are distinct yet connected and must be considered in turn rather than in composite. I follow this guidance by turning first to the substance of the duty to prevent, which I can take shortly. because, as the court observed in the Bosnia judgment, logic dictates that a state cannot have satisfied an obligation to prevent genocide in which it actively participated. That is what happened here. Because Myanmar committed genocide, it obviously failed to prevent genocide. Because genocide was committed by its own state organs, it obviously had the capacity to influence their conduct. It had knowledge that genocide was going to be committed, and far from taking any reasonable steps to prevent genocide, it deliberately endorsed and perpetrated it. Myanmar also had relevant knowledge of the commission of genocidal acts by ethnic Rakhine civilians. And yet, far from taking steps to prevent them, Myanmar incited them to join its genocidal campaign. There has been a flagrant breach of the duty to prevent. Alongside and subsequent to that violation, Myanmar has also violated the duty to punish genocide, as contained in Article 1 and supplemented by the content of Articles 4, 5 and 6 of the Convention. This collection of obligations together places on states parties clear duties to respond in the face of genocidal acts by way of prevention and punishment, and to create domestic frameworks that inhibit and deter the commission of genocide. The duty to punish arises notwithstanding that Myanmar was itself the perpetrator of genocide. It nevertheless had and has a freestanding obligation to punish the individual perpetrators, including its highest military commanders, who conspired to commit genocide and who ordered and orchestrated its implementation. The court explained this in the Bosnia judgment, saying that it is perfectly possible for a state to incur responsibility at once for an act of genocide and for the breach by the state of its obligation to punish the perpetrator of the act. These are two distinct internationally wrongful acts, and both can be asserted as bases for the state's international responsibility. That is precisely the Gambia's case, that Myanmar is internationally responsible for genocide and simultaneously for breaches of the duty to punish genocide. The question that arises, therefore, is what is a state required to do in order to discharge the duty to punish? This question is answered in detail by the joint interveners, and the Gambia agrees with their position. The duty to punish must be interpreted as an obligation to investigate and prosecute people accused of genocide, and to punish persons found to be guilty of genocide. The duty imposes an investigatory obligation because this is a necessary step to imposing lawful punishments. As with all provisions of the Convention, the content of the duty to punish must be interpreted consistently with the rules of international law, so that fair trial guarantees are implicit in it. And independent investigations are thus required to provide a proper basis for genuine and impartial trials capable of imposing lawful punishments. As the court explained in the Belgium v Senegal case, there in the context of the obligation to inquire about acts of torture, while the choice of means for conducting a criminal inquiry remains in the hands of the state concerned, the state is obligated to proceed effectively with adequate investigations. An equivalent requirement is imposed by the duty to punish in the Genocide Convention. Myanmar suggests in its counter-memorial that the duty to punish is an obligation of conduct and not of result. The intervention of the Maldives helpfully explains why Myanmar is wrong about this, and the Gambia fully agrees with their analysis. A respondent state cannot avoid responsibility for breach of the duty to punish by claiming that such failure arises from external factors which have impeded its ability to punish perpetrators. If the evidence shows it has in fact failed to punish them, either for genocide or for the other genocidal acts described in Article 3, it has breached its obligation to punish, irrespective of the reasons it may give for that failure. This may, however, be an arid debate in the circumstances of this case, because although Myanmar asserts that the duty to punish is an obligation of conduct and not result, it does not point to any conduct that it says it took to discharge this obligation. The essence of its case is simply that no genocide occurred, and that therefore no duty to punish arises. Members of the Court, the Gambia agrees that the duty to punish only arises if genocide has been committed. But the duty to investigate, which forms an essential part of the duty to punish, arises as soon as there are reasonable grounds to believe that genocidal acts have been committed on a state's territory. The Gambia and the interveners which address this topic agree that this is the relevant trigger for engagement of the duty to punish in its investigatory modality. Myanmar posits an alternative, higher threshold, that the duty to punish only arises when the authorities have already obtained sufficient evidence to satisfy the evidential threshold under municipal law. There is no basis for importing that position into the Convention, and it would be wrong to do so for obvious reasons. The introduction of such a requirement would incentivize a respondent state to turn a blind eye to evidence or refuse to take reasonable steps to obtain it, so that it never held sufficient evidence to satisfy its municipal threshold and thus trigger the duty to punish. And it would incentivize a respondent state to set the municipal evidential threshold so high that it could not be met, so that the state could evade coming under a duty to punish. Such an approach would undermine the effectiveness and the very purpose of the Convention. The Gambia invites the Court to reject Myanmar's position on the applicable threshold. I turn then to the evidence on failure to punish. My colleagues have taken you through it, particularly in Professor Darjon's speech yesterday, and I need not repeat what they have said. It is clear from the record that Myanmar would have been aware contemporaneously that there was a widespread belief that genocidal acts took place during the clearance operations. There were certainly reasonable grounds for believing that to be the case. And therefore, the duty to punish, at the very least by carrying out effective investigations in good faith, has been triggered. Myanmar is certainly aware of that now. But it has taken no meaningful action to investigate, much less prosecute or punish the perpetrators of genocidal acts against the Rohingya. Professor Darjon addressed you yesterday on impunity as an indicator of genocidal intent. And the evidence that the UN fact-finding mission collected and presented in respect of that indicator also supports the Gambia's case that Myanmar has violated its duty to punish. Isolated examples of prosecutions, none of which were for genocide, do not alter this position, not least because the few examples that exist are deeply flawed for the reasons Professor Darjon explained. As the UN mission noted, the default approach taken by Myanmar has been to deny Tatmadaw responsibility, and only when these approaches fail to deflect attention, to undertake some form of investigation which generally does not comply with international investigative standards. The few examples that exist, therefore, do not assist Myanmar in showing adherence with the duty to punish. the UN fact-finding mission concluded that the state has not undertaken an effective investigation into genocide, even though such investigations are, as I have said, the critical first stage to discharging the requirements of Articles 1, 4 and 6 of the Convention. Nor have there been adequate prosecutions or other means of punishing the perpetrators. In totality, both in respect of genocide itself and in respect of the other genocidal acts to which I will turn later in my speech, there has been a clear violation of the duty to punish. There has also been a clear and ongoing violation of the duty to enact legislation under Article 5, which is itself a facet of the duties to prevent and punish. The UN FFM explained in its 2019 report that Myanmar's penal code has no provisions on the crime of genocide, an omission that is underscored by Myanmar's belated amendment to its penal code in 2021 to introduce an offence of genocide. The Gambia welcomes this development of Myanmar's municipal law, but the 2021 amendment still fails to give effect to the Convention, in particular because it does not apply to members of the Tatmadaw, who are subject to a separate military criminal code, which still fails to criminalise genocide, and who, therefore, despite being the predominant perpetrators of the genocide against the Rohingya, remain fully insulated from investigation or punishment for their genocidal acts. The new law also provides a carve-out for existing laws, meaning that measures introduced to restrict births in the Rohingya community under pre-existing laws that authorise such measures are insulated from prosecution under the Criminal Code, despite their genocidal character. The 2021 amendment therefore fails to meet the requirements of Article 5 of the Convention, and the Gambia thus invites the Court to determine that, alongside its commission of genocide and its associated failure to prevent genocide, Myanmar has also violated the duty to punish genocide, including the duty to punish other acts prohibited under Article 3, and by failing to put in place a domestic framework giving effect to the Convention. Mr. President, members of the Court, I turn now to the other prohibited acts for which the Gambia says Myanmar bears international responsibility. Our memorial addresses each of the acts contained in the 5 sub-paragraphs of Article 3, and we maintain what is said there about them. For the purposes of today, however, I will only address you on 2 of them: conspiracy to commit genocide in Article 3b of the Convention, and direct and public incitement in Article 3c. This is because the other violations which may be committed under Article 3 have been recognised by this Court to be either absorbed by or logically inconsistent with a finding that a respondent state has committed genocide. Since the core of the Gambia's application is that Myanmar committed genocide, and since, on the Gambia's case, the evidence presented to you this week convincingly establishes that it did, it is unnecessary for me to address you or invite that you make specific findings in respect of other acts which are encompassed by or would be inconsistent with that primary determination. The position is different for conspiracy and for direct and public incitement. While in certain factual situations, a court may consider that a finding of conspiracy or direct and public incitement is subsumed by a finding of the commission of genocide, these may, in other cases, be analytically distinct, and they may be worthy of distinct findings. The Gambia says that that is the case here. It is perfectly possible for a state to conspire to commit genocide and go on to commit genocide, as Myanmar did. So too is it possible for a state to incite others to commit genocide and also commit genocide itself. And the Gambia submits that that is precisely what happened here. These additional violations of the Convention, in the circumstances of this case, justify their own distinct findings by the court. On conspiracy, I can be brief. A conspiracy to commit genocide arises when organs of the state enter into an agreement to commit genocide. A conspiracy may arise whether or not genocide is ultimately committed. And if genocide is committed, that does not displace the existence of the prior conspiracy to do so. On the evidence in this case, of course, the Gambia invites the court to conclude that a genocide did take place. But before that, Myanmar entered a conspiracy to commit it, because there was an agreement to act as it did between its highest leaders and military authorities. That agreement can be inferred from the highly coordinated nature of the clearance operations and from the dissemination of the Facebook posts and other materials indicating the existence of a plan which necessarily required agreement among its organisers. Agents of the Myanmar state were party to the agreement, including senior members of the Tatmadaws Officer Corps, the Commander-in-Chief, members of the Tatmadaws General Staff, and the commanders of the Tatmadaw units that carried out the clearance operations. The people who held these roles have been named by the UN fact-finding mission in its reports, which concluded that each of them should be investigated and prosecuted for genocide. Arrest warrants for some of them, including the Commander-in-Chief and the Deputy Commander-in-Chief of the Tatmadaw, have been issued by Argentina in the exercise of universal jurisdiction for the crime of genocide. But Myanmar has taken no steps of its own to investigate or punish the conspirators. Indeed, given their role as senior commanders of Myanmar's armed forces and government, their conspiracy was Myanmar's conspiracy. Alongside a finding that Myanmar committed genocide, the Gambia invites the court to hold that it also conspired to do so, and that it has failed in its duty to punish the individual conspirators. Finally, on direct and public incitement to genocide, a state will be responsible for this punishable act when a state organ speaks, publishes, or displays in public words that incite, which is to say, encourage or provoke the commission of genocidal acts. In its Radio Milcoline judgment, the ICTR appeal chamber made clear that to determine whether speech constitutes incitement to genocide, it must be considered in its context when reviewing its potential impact. The court must consider how the words would be understood by their intended audience, so that it is open to a court to conclude that a speech which contains, and I quote, no explicit appeal to commit genocide, or which appeared ambiguous, still constituted direct incitement to commit genocide in a particular context. The ICTR Appeals Chamber in that judgment also endorsed and applied what was said on the correct approach to direct incitement in the Akayesu judgment, namely that the direct element of incitement should be viewed in the light of its cultural and linguistic content. Indeed, a particular speech may be perceived as direct in one country and not so in another, depending on the audience. The Chamber further recalled that incitement may be direct and nonetheless implicit. A similar finding was made by the Supreme Court of Canada in the Mugasera case, that the direct element of incitement should be viewed in the light of its historical, cultural, and linguistic context. And so, the history and context of discrimination and the long-standing denigration of the Rohingya that Ms. Pasipanojga addressed you on at the start of the week are thus directly relevant to the proper interpretation of the statements made by Myanmar officials and to the court's assessment of whether they constitute direct incitement to genocide. So too is the evidence of hate speech on which Mr. Suleiman addressed you. The Gambia accepts that there is a difference between hate speech and direct and public incitement to genocide, in that incitement always involves the additional requirement that the speech is understood by its intended audience as a call to violence or action against the derided group. Hate speech may also include calls to violence, and the definitions referred to by the UN fact-finding mission, including the 2017 Rabat Plan of Action, do address hate speech, including that which incites violence. The UN FFM also noted that Myanmar's hate speech against the Rohingya includes incitement to violence. And so while they are distinct, there may, as in this case, be considerable overlap between hate speech and incitement. The Mil Colleen Appeals Chamber judgment recognised this relationship, saying that in most cases, direct and public incitement to commit genocide can be preceded or accompanied by hate speech, as indeed it was in the case of the Rohingya. Hate speech also contributes to the relevant context, affecting how statements are likely to be received. The UN FFM recorded that it has no doubt that the prevalence of hate speech in Myanmar significantly contributed to a climate in which individuals and groups may become more receptive to incitement and calls for violence. That certainly seems to have been true for the ethnic Rakhine civilians who were ripe for incitement to genocide and who joined the Tatmadaws' genocidal efforts, for example, in Chutpin and in Din, as you were told earlier in the week. The fact that the Commission of Genocide did in fact follow is a factor that, as the ICTR Appeals Chamber observed, will assist the court's interpretation of the words in question, casting light on the fact that, in their particular context, the speech was understood to be an incitement to genocide, and that this was indeed the intent of the author of the speech. On Monday, Mr. Suleiman took you to potent examples of Myanmar's hate speech, several of which also constitute incitement. I am thinking, for example, of Senior General Haing's September 2017 speech, making inflammatory allusions to the Rohingya and calling for all to be loyal to the state, right while the clearance operations were ongoing, and loyalty to the state would be understood as loyalty to and assistance of their genocidal campaign. There are further examples on the evidential record which also satisfy the legal test that in the relevant context, they would be understood by their intended audience as a call to genocidal violence. For now, I draw your attention to just two examples drawn from the Facebook evidence which Mr. Suleiman addressed on Monday. First, a video posted on military pages on Facebook in August 2017, as the second wave of clearance operations were in their early stages. The video, reported on by the UNIIMM in its analysis of the material provided by Facebook, shows a soldier inciting ethnic Rakhine civilians to genocide. He told them, and I quote, "We will clear the villages where those animals live. We have guns, we have bullets, that's what we came with. With ammunition and the spirit to attack the animals, we have come here. If you can carry a sword, carry a sword. If you can carry a stick, then carry a stick. Carry whatever you can and bravely face these animals." In its context, this was a clear encouragement of genocidal violence against the Rohingya, and it falls within Article 3C. Days later, in early September 2017, as the clearance operations continued, Tatmadaw Facebook pages posted a message calling on ethnic Rakhine to, and I quote, "sharpen even the knives at home that you do not use." The post also alluded to historic violence allegedly committed by Muslims against Buddhists. In the context that existed in August 2017 in Myanmar, a post referring to Rohingyas and telling Rakhine to sharpen their knives would be well understood by its intended audience as incitement to genocidal violence against the Rohingya. The evidence shows that they were indeed understood as such. Mr. Suleiman took you to some of the responses posted under other similar Tatmadaw posts. Comments which said, "Don't leave any of those Muslim dogs alive and make them extinct." These and other examples on the record demonstrate convincingly that senior Tatmadaw officers openly exhorted soldiers and ethnic Rakhine civilians to commit genocide against the Rohingya. In the context of the long-standing vilification of the Rohingya by the Myanmar government, there could be no mistaking the genocidal appeal being made, and the evidence to which the court has been taken shows that the appeal was heeded. The Gambia thus invites the court to find that Myanmar, alongside its other breaches of the Genocide Convention, is also internationally responsible for direct and public incitement to genocide. Mr. President, members of the court, these, therefore, are the key substantive violations of the Convention which the Gambia pursues through this application. First, that Myanmar committed genocide. Second, that it violated the duty to prevent genocide. Third, that it violated the duty to punish, including the associated duties to try and to have in place domestic legislation giving effect to the Convention. Fourth, that it entered a conspiracy to commit genocide. And fifth, that it directly and publicly incited genocide. It is also part of the Gambia's case that Myanmar has breached the court's provisional measures order, a topic that Mr. Suleiman will address you on next. I thank you for your close attention this morning. And Mr. President, I ask that you now invite Mr. Suleiman to the podium to continue the